Hello and welcome to episode 10 of the Estate Planning Academy. I'm your host, Gary DeWitt, and this is the internet's most passionate show about estate planning. Today's topic is about last wills and testament. There's a few definitions that you'll hear thrown around when you talk about a will. The executor is a male in charge of the probate process. An executrix is a female in charge of the probate process. Your administrator or administratrix is a male or female in charge if there isn't a will. The words personal representative are modern terms to replace the preceding four terms. A testamentary trust is a trust created by a will. A holographic will is a will that is completely handwritten. You need to know, a will alone will not prevent probate. A will and some other planning may prevent probate. The drawbacks of a last will and testament. By definition, a will doesn't go into effect during your lifetime, so there's no lifetime protection. By itself, it is not a probate avoidance device. It requires probate to be validated, then administration for everything in it to be passed out to your heirs. You can think of a will like a letter to the court telling the court how you want your property distributed. You can't easily put conditions on the gifts you leave, and you can't leave money to pets in a will in Arkansas. However, you can set up a pet trust. In Arkansas, you have to be 18 years old or older, know what you have, we call it your bounty, know who you want your bounty to go to. If typed, it needs to be witnessed by 2 witnesses, and it really helps if there's a self-proving affidavit, which is where the witnesses sign in front of a notary so they don't have to be called back to court later. Arkansas recognizes handwritten wills, also called a holographic will. The entire body of the will and the signature shall be written in the proper handwriting of the testator meaning the person writing the will. The will may be established by the evidence of at least 3 disinterested witnesses to the handwriting and signature of the testator. Disinterested means that the people aren't mentioned in the will. Now, wills do have a few advantages. There's already a judge involved to settle disputes. You decide who gets what and how much, but not exactly when. You nominate guardians for minors, and you can use a will to create a trust. However, wills have several disadvantages as your main planning tool. They don't give you any lifetime protection. You have to go through probate. Probate makes the will public. They're easier to challenge than a trust, leading to higher attorney fees. No or only very simple conditions on final gifts, and money given to minors will usually be held in a court-appointed trust, then given to the children in a lump sum at 18 years old.